Constitution. So we're going to lower all rents by 20%. And as a result, because of the cost of insurance and electricity and that sort of thing.
When does the president need Congress to authorize military force? It sounds like a straightforward constitutional question. Welcome to American Hearings. Senator Kennedy just put that question to a judicial nominee. And what followed was a masterclass in what happens when a direct question meets an indirect answer. Kennedy's patience is visible, and then it isn't.
When does the president have to get permission of the United States Congress to use military force?
Well, Senator Kennedy, as I was discussing with Ranking Member Durbin, I do want to be careful about hypotheticals in terms of prejudging.
It's not a hypothetical. I'm asking what the Constitution says. When does the President of the United States have to get permission from Congress to use military force?
Generally, Senator, my understanding is the divisions between Article 1 and Article 2 distinguish between the war powers, which are under Article 1 and require congressional consent. Again, talking in great generalities, whereas other use of force, if I understand your question, are things that are likely committed under Article 2 to the President's commander-in-chief powers.
I have no idea what you just said, Mr. Hendershot. Let's try it again. Tell me when the President has to go to Congress to get permission to use military force.
Senator, I think is when, because the text of the Constitution, Article 1, talks about declarations of war, those would be circumstances where the President would, in a general sense, and use of force that is not war under the commander-in-chief power, I think those are under Article 2 without the consultation of Congress.
Okay. I'm sorry, I don't mean to be rude. I just don't understand what you said. Mr. Jones. Let's suppose the mayor of a city, strike that. Let's suppose the mayor of a city goes to his or her city council and gets a rule freezing rents. You with me?
Yes, Senator.
Freezing all rents.
Yes, Senator.
Forever and a day. Let's make it even more interesting. Reducing rents by 20%, because housing is a problem, right? Cost of housing. Let's suppose it to try to help people with housing costs, the city, mayor and council, uses its police power under its state constitution as recognized by the federal constitution. So we're going to lower all rents by 20%. And as a result, because of the cost of insurance and electricity and that sort of thing, about half of the landlords in the city just say, look, we're going to have to default on our mortgage. Constitutionally, can the city do that?
Well, Senator, I think it could depend. I do think the city could have some ability to freeze rents. But I think you would have to look at the
Why isn't that a taking?
Well, it certainly could be a taking. And
when does it become a taking? At what point?
Well, I think it would have to be, you'd have to initially look at the impact, the financial impact on the taking of what could amount to a property.
Let's suppose, that's fair, yes, sir. Let's suppose 40% of the landlords will default on their mortgage. Have you reached the point of a taking or not? And how do you determine when you reach the point of a taking?
Well, again, I think it could depend, but there would have to be a showing that, what the financial impact was. And
Yes, sir, I'm sorry, I don't mean to be rude. We just have so little time. I understand that you have to have a showing. Tell me what the rule is.
Well, I think the rule is if you're taking property without, the government, I should say, taking property for a legitimate government purpose, I think you can only do that by compensating the owner of the property.
So
Generally,
any freeze on rent is a act of eminent domain? Is that
Well,
what you're saying?
not necessarily, Senator. I think in your hypothetical, you were, at least as I understood it, we're talking about a financial impact, not just freezing it at the moment, but then going on down the
Okay.
road.
In the hypothetical I gave you, who's going to win if the landlord sued the city or the landlords?
Well, I think, again, it would depend on the
You're
length.
not going to give me an answer, are you?
Well, I think it could depend. I know that's a very lawyerly answer, Senator, but
Yes,
I
sir, it
think.
is,
I
very
think it
hard.
would depend on.
Judge, let me ask you a question in the few minutes I have. Tell me under what circumstances the state legislature can draft a statute that makes a distinction that classifies people on the basis of race.
Senator, I think, Chair Grasso, may I answer?
Yes, and then we'll go to Senator Goins.
Thank you, Senator. I think the circumstances would depend on the specifics of United States Supreme Court
I
case
know.
law and
Just give me
the
some
state
examples.
constitution.
Just give me
at
some
issue.
examples.
Senator, on the basis of race, I don't think, I think in the United States Supreme Court has held that there should be no classification.
No, they've just said you got to have a compelling reason.
That is true, Senator.
So tell me what would be a compelling reason.
Senator, as we sit here today, I cannot give you a compelling reason.
Okay, I appreciate your honesty. Thanks, Mr.
Welcome back to American Hearings. Kennedy opens with one of the most fundamental questions in American constitutional law. When does the president need congressional authorization to use military force? Simple question, important answer. The nominee responds with a detailed breakdown of Article 1 and Article 2 powers. Technically accurate, genuinely difficult to follow. Kennedy's response, delivered without a trace of sarcasm, is that he has no idea what was just said, and could they try again? This is not a gotcha moment. Kennedy isn't being dismissive. He's holding the nominee to the standard any future litigant in their courtroom would deserve: clarity. The second attempt is cleaner, but Kennedy moves on rather than press further. He pivots to a rent control hypothetical, a city mayor and council freezing, then reducing rents by 20%, causing mass landlord defaults. Is that a constitutional taking of property? The nominee's answers are carefully qualified at every turn. It could depend. There would need to be a showing. Kennedy keeps narrowing the lane. At what percentage of defaults do we reach a taking? Who wins if landlords sue? Each time, the answer retreats into, it depends. Kennedy names it directly, very lawyerly. He's not wrong. And the closing exchange on racial classifications under Supreme Court precedent follows the same pattern. The nominee knows the doctrine exists, acknowledges compelling interest is the standard, but won't construct a single example of what that might look like. To be fair to the nominee, these are genuinely difficult questions. But a lifetime federal appointment means someone has to answer them eventually, from the bench, under far higher stakes. Kennedy's questioning style is a preview of that pressure. Subscribe to American Hearings,